Hi, my name is Eduardo Garcia, and I'm here again with Marshall Fitz, who's the Director of Immigration Policy at the Center for American Progress. We're going to do a little more talking about this upcoming Supreme Court case regarding Arizona's SB1070. So, Marshall, what's your thinking on this case? We know who makes up the Supreme Court. Do we have any sort of indication over how they will come to a decision this summer?
That's a great question. It's what court watchers do is they speculate and they try to figure out which justices are going to lean in what direction, and we may know more, may have a better clue after the argument, which is scheduled for April 25th. But from my perspective, the claims that the Justice Department has made in this case that these four provisions that we've discussed are preempted. And that the state cannot engage in these activities are very strong. I would not be at all surprised if we had a 5-3 decision. There's going to be one justice, Justice Kagan, who's recused from the case because she was the Solicitor General when the case originated in Arizona in the lower courts. She basically said, well, I was involved in this case when I was actually working for the Department of Justice as the Solicitor General, and so I have a conflict of interest because I argued one side of this case, and so I'm going to take myself out of it. And justices do this on their own. They're not told that they have to, so it's kind of their own conscience as to whether or not they need to do this. Some people say, well, okay, there's been 5 justices that have been appointed by Republican presidents, and 4 that have been appointed by Democratic presidents, and she's one of the 4. So does that mean we're, that if they were to just go along party lines, and it's not inconceivable that you could see, and we have seen votes that do kind of track those party affiliations. But if it were, what does it mean that she is not going to be one of the votes? Well, actually, it's really not all that different than even if she was there, because a 4-4 decision means that those 4 provisions in the Arizona law will be struck down, because a 4-4 decision means that the Ninth Circuit's ruling that blocked those provisions will remain intact. So what that means is that one of those 5 Republican-appointed justices does need to join the liberal block of the court, and the most obvious target is Justice Kennedy. He has tended to be a swing vote in a lot of these high-profile, narrowly divided cases over the years, and so presumably we can expect both sides to be speaking in the oral arguments, to be speaking very much to him and trying to persuade him to be on their side. So, so a 4-4 split means we win, and I say we because we are obviously strongly supportive of the Ninth Circuit's ruling.
My follow-up question to that would be, as we anticipate their decision this summer, depending on the outcome of the case, we will have very different outcomes at the local level over how laws like this are practiced. So it might motivate states that have in previous legislatures tried to enact similar laws. What would happen if this case gets struck down, or if this law gets struck down with this case? And then on the flip side, what would happen if they get, if the provisions don't get struck down?
It doesn't mean it will be the end of the case, and that's really important for people to understand, is that there are a host of civil rights lawsuits that are also pending, and they're kind of everything is waiting to see how the court rules on this case. And there are also a number of other provisions, some more extreme, but a variety of other provisions that will continue to be subject to litigation. In Alabama, there was the schools provision that basically said that schools needed to identify which kids were undocumented or which kids had undocumented parents, and that in the first week of school, 2,000 Latino kids in Alabama didn't show up. So that's not that issue isn't being decided here. If the court does say those provisions can go forward, this could spiral out in a lot of different ways. But what we're most concerned about, so that's kind of the legal side, is like what could happen with the different laws and what the different lawsuits. Again, the all the issues aren't in front of the court.
Right.
And
there are other states that have their own provisions that are being that will come up.
Yeah. But I think more consequentially is, you know, what will happen in these states. You know, that we saw the fear that was generated when SB1070, the Arizona law, was enacted. A lot of people left the state. A lot of people, you know, kind of packed their bags the night that the HB56, the Alabama law, was allowed, that some of those provisions were allowed to go in effect. We saw people literally overnight packing their bags, you know, some of them leaving their pets and fleeing the state. And, you know, so the climate of fear that has been triggered just by the debates over these issues in these states has been profound. And now if the Supreme Court blesses it and says, we're not going to protect you, you know, communities of color, I think, are going to feel very much under siege in these states. And, you know, that hopefully, hopefully we don't come to that. But if we do, it's likely to have a really galvanizing effect and hopefully a mobilizing and energizing effect on people to, you know, to take control where they can, which is in the political process, because that will be the only recourse or the only remedy.
Got it, got it. Thanks so much to Marshall Fitz for joining us for this conversation. We'll be following this case as it approaches in the Supreme Court. Thanks
for having me.
Thank you.